I'll quickly introduce Indian Lawyers Association, ILA, to all of you. So we are a national level organization here to support the legal professionals across the country. And we do this by having chapters at a local level, which adds a lot of local flavor, and a lot of legal professionals, lawyers are coming forward to take up these chapters. Namrata recently joined as the president of ILA Agra. We do events, activities, webinars that help people share knowledge, and a couple of initiatives for students and young lawyers to support each other. Mentoring and guidance initiatives are undertaken. So by the end of this session, or latest by Monday, we'll be very happy to send a detailed email to all of you. And should you be interested to join ILA in whichever capacity, we would love to welcome you. Thank you so much. Over to Smita.
Thank you so much. I can see a tremendous amount of participation. A lot of you were interested in the topic, and as the topic suggests, let me remind you what the topic is. It's safeguards for IC members from liability and retaliation. So the law has been on since 2013, and I've heard when I published this on ILA and KELP-HR forum and various other forums. So I got a lot of feedback saying, thank you for thinking about it. In fact, we as panel members were brainstorming and said that, okay, I think we are first of its kind to be discussing this. So we are very, very happy to be sharing what we think about it, and we would be very happy if you participated in this discussion, because we strongly feel it is a joint effort and cannot be run single-handedly. Namrata was saying this in one of our earlier discussion, who is the panel member. She was saying this, that it cannot be done single-handedly. So we need all and more hands on deck here, right? So a little bit, Adra already mentioned about ILA. I'm going to tell you about KELP-HR. We started in 2013, and the idea was to help the country, the entire country, understand what this law is, and in simplified version. If you look at it, many lawyers work in this space, and while they know their subject really well, what KELP-HR's attempt is to try and understand from them and massage it in a language which will reach out to Janta, right? And be able to tell stories out of it, share experiences out of it. So KELP-HR has been constantly doing that kind of work. We have around 550 organizations plus who are tied up with us, and we are pan-India based. Very happy to work with anybody who would want to work in this space. Yeah? About me, I have total now 23 years of work experience. I'm primarily an HR person, but have heart of a storyteller, all right? And I do work in diversity, equity, and inclusion. I was called out or named in Global Diversity List 2020. I was the only Indian who was listed there. So I'm very proud of that, and I'm showing off. Okay, so amazing panel here. 3 strong women, and we met prior to this discussion, and so much of fun we had in the entire conversation. So I'm going to try and introduce each one of you. Please pardon me if I don't do justice to the introduction. Please tell Smita you missed some important points, and I would be happy to, and I'm sure the audiences will be happy to hear. So first and foremost, let me introduce Advocate Namrata Mishra. She's an independent legal professional, director of a leading e-learning company, and a leading face of Agra, Uttar Pradesh, imparting legal awareness on various women-related subjects. So her research and academic papers on women and children have been published in numerous journals, proceedings, and even covered in International Bar Association. Today, she's an acclaimed speaker. You will see her. She's very powerful, dynamic speaker in POXO, POSH, voice sensitization program, gender discrimination sessions, women empowerment. She also works for Ministry of Women and Child Development and Ministry of Communication. As the State Vice President of Uttar Pradesh Anti-Sexual Harassment Council, she's creating mass awareness on sexual harassment of women at workplace as a trainer. She's working as an external member for various internal committees in Uttar Pradesh, and she has been recently conferred the Global Goodwill Ambassador Award from USA and Rex Karamveer Chakra Award Institute by United Nations in 2019 for her amazing, commendable work. So welcome, Namrata. So I am going to introduce you to another dynamic speaker. She is Trupti Kumar. She also is very much part of KELP HR, and we're very proud to be associated with her. She brings with her more than a decade's experience working as a legal counsel in law firms and in-house. And today she heads an all women legal team pan-India. Trupti is president of WICI Corporate Governance Council Karnataka. Her multifaceted professional voyage includes working as a litigation counsel and corporate lawyer for a diverse portfolio of clients operating across a broad spectrum of sectors. She's a posh SME. When she speaks, everybody stops speaking. So I have personally experienced that. And she's a member of internal committees under POSH Act. She's also involved in labor and employment related matters and is also a part of many POSH forums, a member of UN Women Generation Equality Forum, He for She Commitment movement, which is actively involved in eradicating gender-based differences at multiple levels globally. So she's a rank holder, university rank holder in BA LLB honors, and holds a master's degree in international business laws with distinction. Amazing. That's another power packed woman. And our youngest person on the group here today is another power packed woman. She is Anju Nair. She's a senior associate with ICUL, Bangalore. Anju has earned a bachelor's law degree from Bishop's Cotton Law College, and she has about 5 years of experience in field of civil, criminal, and corporate litigation. While we were discussing, Anju taught me a couple of things which I was so unaware. Thank you, Anju, for that. She brings in that aspect of sharing, caring. That's what Anju is. As part of litigation team, Anju has assisted several financial institutions and individual clientele in initiating and defending various criminal matters, recovery proceedings, property-related matters. Okay, with her sheer inquisitiveness and experience in investigations of allegations of sexual harassment and her inclination towards protection of women's rights, Anju has assisted several clients to protect their interests and defend offenses against women. So Anju has been regularly representing clients before various judicial and quasi-judicial authorities on issues emanating out of domestic violence. So, and various other offenses. So welcome, Anju.
Thank you.
Okay. Before we get started, I want to do one small announcement. You all are aware that POSH Awards is something that KELP HR launched, and 28th October is the last day for you all to apply for it. This is available, the details of it is available on KELP HR website, as well as our POSH Awards website. Please go and look at it. We're very keen for many organizations to apply and see where they are, what they are, how good they are doing, some best practices emerging. We are the only organization in India or in the world doing anything like this, all right? So be part of our craziness. So I'm going to stop share and invite the panel members right now, right here, okay? And I am going to start, before this gets started, why this topic came into our heads, all right? So I wanted to tell you all that when I started in 2013, KELP HR, I had many folks coming to me, many IC members who were called IC members or nominated as IC members, coming up to me and saying, Smita, what about me? How am I protected? What happens to me? You know, so they had so many questions, they still have. Whenever any new IC member or even the existing IC members, they always have these questions saying, what happens to me? Okay, this is an additional day. This is not my day job. This is an additional role I have to play. So how do you think organizations protect me or the law is protecting me? So we said, let's come together and brainstorm about this. So that's why I have you. So Namrata, I'm coming first to you. First of all, I hope I did justice to your introduction. And secondly, I would want to hear from you about any apprehensions or challenges that any IC members would face in this whole aspect of POSH as a law and additional responsibility that they have to run with.
You, Smita, like I'm truly honored and humbled to be introduced. And thank you, ILA and KELP HR, for giving me this opportunity to address and to participate in this panel discussion, first and foremost. Then, like as IC members, I feel that there's a dichotomy that we all are facing right now in India. On one hand, this law is made to protect, address, and redress the dignity of women at workplace and to safeguard their interests with special legislation, specific legislation, rules, and policies. And it is actually laying emphasis on the inclusion of women as external committee members, and 50% of the quorum of the IC team, IC committee is also happens to be women. So our job is, in a way, according to me, very glorified. We are regarded as the guardians for the safeguard of women in workplace. But on the other hand, I don't know that how the lawmakers have completely forgotten to safeguard the interests of IC members. There's nothing written in POSH Act or POSH law rules, and it's not talking about our own safety and well-being. We IC members, we act as neutral members. Our role is okay to investigate and fact-finding committees, fact-finding bodies we have, but we are conferred the quasi-judicial powers. And if we are being conferred these powers, then why have we been denied similar safeguards that are provided to the even the judicial officers? And that's why I think that it is very unfair, and I must, in fact, say thank to you, thanks to KELP HR, thanks to Indian Lawyers Association, that you have thought to address this very important issue. So thank you, in fact, that at least we are discussing today on this forum and we are brainstorming this issue.
Yeah, thank you, Namrata. Thank you for that input. That even the judges, we are called quasi-judicial forum, but we do not even have those protection that normal judges would have. So yes, it's a thing to think for and see how we can make a difference. So I'm coming to Anju. Anju, now I want to hear from you. What is that challenge or one input that you would want to start this conversation with today?
Firstly, to start off with, like Namrata said, I think this is one topic that is not spoken as much as it should be, because we talk about how we protect women, we talk about what are the safeguards available, what are the actions, disciplinary actions that can be taken against respondents, but no one really talks about what is the kind of protection that you can provide to an IC member, which is extremely relevant and which is one of the most important aspects of POSH Act. And it's really sad that the most important aspect has sort of, taken a drawback in setting up this entire regulation. And with regard to the challenges, I think there are numerous challenges that the IC members face, again, which are not addressed at all. There are no, proper laws formulated to sort of protect them. Again, like Namrata said, the body constituted is considered to be a quasi-judicial body. The members are considered to be equivalent to judges. But the question which arises is, what are the sort of immunities that are provided to them? Judges are provided with a lot of safeguards, protection, and immunity, while the IC members lack all of them. So I feel that there are, certain amendments which needs to be brought into picture. For example, maybe any coercive actions or threats against an IC member should be considered as a serious offense, and they should be taken in a cognizable nature. So probably this amendment will sort of regulate the formulations that's already been laid down and give them a protection, so that people who approach them will sort of take them in a more serious manner and not just as a fact-finding body or a preliminary inquiry conducting body.
Yeah, you're right. There are times when we are not regarded, maybe because we are an internal set of people. So they are like, okay, just they're just playing around with us. So maybe that seriousness is required, and maybe through our awareness programs we'll be able to draw that, right? So Tripti, I come to you, and I hope I made enough justice to your introduction too. And what is that, those challenges that you think as an IC member, internal or external, we would be facing, and we need to speak about it and bring it on table?
Good morning, everybody. And firstly, thank you, Smita. You really make all of us look much better than we actually are. And thank you, not just for the opportunity to address this issue, but also to give a stage to three of us, such esteemed panel members with who you can really brainstorm and come together, because finally the cause here is all of us coming together and fighting for a common cause that we all feel about and, are able to deliver something. Coming to the IC role, now I had the privilege of playing it on both sides because I moved from firm to in-house to firm to in-house. So there are times when I was external member and there are times when I am internal, as an employee of an organization. So I have seen it from both sides. And there are so many elements at play. So I will take a step back here and say, forget safeguard once you become an IC member. I think there is also a very serious gap in preparing you to be an IC member. Now, someone like me who comes from a legal background and understands a mentality of our lawmakers is able to add some intelligence and value. But now you have brought together people who come from technical fields, marketing, delivery, your sales team. Now, these are people who are entering into an alternate universe, and you have given them powers of a civil court. You have told them you're a quasi-judicial authority. At the same time, somewhere organizationally, IC, pardon my language, I may be sounding a little harsh here, but IC is tending to becoming a puppet. Because unlike a judge, when he passes an order, the order needs to be carried out, otherwise it's a contempt of court. But here, IC can only recommend to the employer. The employer has to carry it out. So I think there is a certain intention there for IC to do the inquiry, IC to be trained, provided a skill set so that they can perform this function over and above their existing qualification. Because this is not their qualification, this is not their technical training. This is an independent chair that they are sitting on for an organizational protection and mandate. So this goes beyond the law, it goes beyond technical. It is about an ethical fabric of an organization. It is about humanitarian behavior that we bring in, a safe workplace. Now, while IC is fighting the war like our army, what is the army getting in return? They don't have the training, they don't have the weapons, and now you've thrown them in the battleground. On top of it, they face retaliation, as Anju and Namrata both were mentioning. There are consequences to them, including the fear of losing their own job, because finally, the employer is also their employer, not just the complainants and respondents. So I think there is this gap of firstly equipping the IC to be an IC member, and after that, the safeguards to be given. One is through amendment, in the law, that is correct. But I think also more than that, as an organization, as an employer, what you can do. Otherwise, IC will merely just become a channel and a check mark for compliance, very realistically speaking, practically, rather than actually be a very powerful, very impactful quasi-judicial authority, which walks that authority and talks that authority.
Absolutely, I agree with you. And sometimes, while I know that puppet word is not that great, but it's the feeling. It's the feeling that many a times I feel, I see, and I feel that they also must be feeling. So it's okay to, I think, sometimes bring it on table and say that if this is a feeling, then we need to work towards it. So Namrata, I'm coming back to you, and I want to hear from you that, there are times when IC members are sitting in front of very senior people, and they are having this discussion. There must be somebody whom, who could have influences on IC people's day jobs. So how do you think they can manage such a situation? And how employers can ensure of any kind of protection for them?
Good question. I must say, very relevant question that follows after Tripti is answered. Just like the complainant or respondent, they have the the right to go to court, and if they are able to prove bias. Likewise, I feel that since Posh law is silent on the protection of IC members, then the only recourse that is available to us is that we have to go to court as of now. And until, as already recommended and suggested by Tripti, until necessary and adequate, amendments, and in fact, even Anju has, suggested that amendments need to be carried out under the Posh law. So, but till then, what do we need to do? Because we are already facing what do I say, the biggest discrepancy in Posh law that exists today, and this we are facing. So, one thing that pragmatically the employers can do is to have and to create effective gender neutral policies. Unlike just going to the court under section IPC section 354 ABC, if they have these gender neutral policies, if they incorporate such policies and include even the interest of IC members also in their policies, then their interest may be protected to a certain degree, and providing access of awareness resources to all the employees. And the best, and to do that is, again, I am giving emphasis to awareness, to sensitization, to training, to educate the employees, make their policies more inclusive. Inclusive being not only the employees, but also the IC members, because they are an integral part of Posh now. And so it's high time they must be given importance to, and the respect that they so well deserve. And education is, educating the employees is in one way will try to mitigate the risk, according to me.
All right. Those are such relevant points. There are times when I create awareness also, we are only concentrating on what the employees should know. Okay. According to us, they should know the name of the IC members. But I don't think we spend time to tell them that IC is so powerful, or IC are also human beings. These are good discussions to have. And, these are good inputs, Namrata. So I think we will have to think through that how our awareness programs might also want to change. So Tripti, coming to you now, what do you think about, can you add anything here from the perspective of how do you deal with senior people in your organization, who could be accused of sexual harassment, and these are the IC people who are sitting there. Okay, and it is not a very easy equation. I've seen that body language change. I sit as an external member. For me, it just doesn't matter. But for internal IC members, it definitely matters. So, how and what are your suggestions? I'm sure there are few internal members here sitting in the forum. They would want to know that what is it that they can do differently.
Absolutely, Smita. In fact, this I think is a bigger clincher than even other safeguards, because for you to be able to perform, you need to have a space where you can perform your duties as an IC member very well. And that is something we all agree that today the law is not addressing that. There is a lacuna there. We all understand that. So I think the best way to bridge that is the power given to organizations. It is corporate governance. Very simply, there should be something like IC SOP or guidelines that an organization can introduce. And this can, I'll give you an analogy also. For example, maternity benefit is a statutory right. We all know that. But paternity benefit is not. But a lot of organizations give you that as a policy mandate because they think that it is something fair and something that should be given. Similarly, if I apply this in the current scenario of Posh and IC members, we are having two parents here. IC is the mom and the employer is the dad, and all the employees are getting confused between the mom and dad parenting battle. If I could, draw that analogy, and no offense to all of us who are parents here, but that is where I'm coming from, that a rule book helps. a guideline helps. So as an organization, have an IC SOP or an IC guidelines document. And when you are onboarding your IC members, please understand that they are employees. They have signed an employment agreement, but this is an independent function. It is a statutory function. It's a quasi-judicial function. So when you have your appointment or nomination letter, you're signing with your IC member, in that, guarantee them indemnity, guarantee them safeguards, guarantee them that their ability to perform as an IC member will not impact their regular day job in any manner. And everybody at some level is equal in the eyes of law. So senior member, junior member, your own friend, spouse, sister, parent, you have the option of declaring conflict and stepping down if you feel you cannot do justice to the role. So when the law has given you, as per principles of natural justice and POSH Act, they have given you the power to call out conflict. Similarly, the organization also should be able to understand that there could be a conflict situation and how to deal with it. Because this is going to apply to everybody. Every person who sits on an IC is an employee. So this is going to be it is a global problem. It is not one IC member who has a problem. So I think the best way to do it is give rules, give guidelines, which are within the framework of law that they stand today, but give additional protections, additional safeguards, and more importantly, an atmosphere for an IC member to perform their functions without fear and in an impartial, neutral, and a just manner. Because finally, that is the intention. We all are fighting for getting this done. It doesn't matter which side of the curve we are sitting on. So I think that's my 2 cents to this. It boils down to good corporate governance, Smita, that's all.
Absolutely.
Where the law is not there.
Absolutely. I think they are brilliant. I won't call it 2 cents. They are brilliant inputs, and we will have to see how we can support organizations in having those SOPs and in a way protect the IC members. So this is something that I will definitely take away from there. Anju, I know that we were discussing something on vicarious liability. I hope I've said that correctly. So
Right.
Can you share with all the IC members here what does that mean and how that can protect or safeguard their interests?
Right. So basically, like Tripti said, when you choose a panel, when you formulate or when you sort of bring in an IC committee, it is the employer's responsibility to also protect them. Because when you're putting a panel, a couple of panel members to address the issues of women at your workplace, you can't just leave them hanging there without sort of providing them adequate protection. While the law states that they're considered as judges, equivalent to judges, they have quasi-judicial powers, there is nothing really in writing which sort of protects them. There are no laws formulated, there is no adequate protection given. So the IC members are throughout and constantly in a sort of fear, like Tripti said, they're juggling between, do they protect their employees or do they sort of impress the management? Because any order or a report which is passed against a management can sort of indirectly affect the IC members. And the consequences could even go to an extent of them being dismissed from their job. And they have no protection to that extent, which the court gives them. So where the liability arises of the employer is in the event there is any case, that has been filed by any party against an IC member, it is the duty of the employer to sort of tell the IC member that, listen, you don't have to worry. I'm here. I will take on the responsibility because at the end of the day, you are my employee, and I have put you in this panel. So it is my responsibility to take care of whatever legal action has been taken. Of course, the panel member will have to appear as a witness, will have to produce all his findings, will have to give in his statements. That's a different story, but at least the legal expenses, which is one of the most concerning aspects, because as we all know in India now, the legal expense has, it's, almost shot up to a level like the property value is rising up, even the legal expenses are at its peak right now. So to engage a counsel, to brief a counsel, it's not as easy as it sounds. So I feel the employer should sort of take up the role and should give that adequate protection to the IC members if there are any legal charges that have been availed against them. So this will give them the confidence to pass any order or come to a conclusion in a fair and just manner. If not, there's always a confusion, if there is anything that goes against the management, okay, maybe there is a drawback to me, or maybe it's going to hit me back in a way where I will have to stand on my own feet without having any sort of protection. So like Tripti said again, in the internal policies, I feel this should be added too, so that even before they sit as panel members, they are aware that, I can pass an order in a just manner because I know I am being adequately protected.
Yeah, I think that is very good, great thought process of listing all these aspects, Anju, and you've really brought in important, we generally get an appointment letter, but that appointment letter only tells us what you have to do. It does not tell us how we will protect you, I think that whole thing will need to spin about, and we will have to make it more stronger letter, which is like a two-way commitment, a mutual agreement kind of a thing. Yes, I think that's a very good input. So Anju, I'll just extend this question to you, and I wanted to ask you about retaliation. How do you think employees, IC members, would face the retaliation aspect in the whole, in the whole scenario? I'm sure there will be, because we are human beings, unconsciously or consciously, people are biased, and they don't see it. So it's not very easy for them to disconnect what happened to them in that room of IC and outside the day job. So it is difficult. So what happens from the retaliation perspective, how they can protect themselves?
Yeah, so I'll start off with an example. So for example, there are several instances when there are cases filed against senior members in an establishment. So at that point, like I previously mentioned, the IC members are always in a confusion because the senior members have a sort of power on the IC members, because at the end of the day, they are the employees of the senior executive members. So, there are chances when their arm twisted, or, they're threatened of consequences in the event, any order is passed against them. And the most common, I feel, the most common retaliation is threatening them of a consequence of dismissing them from their position. And a dismissal of such sort is an extremely harsh step, because it's extremely difficult for them to find a new role in a new workplace. Because being an IC member of one establishment and then being dismissed on a ground, of a disciplinary action is an extremely, I think, a black mark on their professional growth. So the High Court, in fact, there was a recent judgment in 2018, if I'm not wrong, it's Sheetal Prasad Sharma. The Bombay High Court, in fact, held that, IC members cannot be dismissed unless they have prohibited, certain aspects under Section 16. Section 16 of the POSH Act speaks about communicating certain intricate details in a complaint. That is one aspect. The second aspect being if they have sort of gone against the principles of natural justice, or if they have, been accused of any crime, if they've been convicted of that particular crime, or if there's any disciplinary actions taken against them. So unless these criteria are met with, the employer cannot sort of terminate the IC member. In fact, this is the first and foremost protection, or if I may say, the most minimal protection that has sort of been provided to the IC members. And the good part about this is this does not really only apply to either a public or a private sector. It combines both, because there's always this discussion that public sectors have more protection compared to private sectors, but this aspect of dismissal sort of protects both public and private sector. So I think it's a great start that the judiciary has taken to sort of implement protection.
Absolutely. And this question is open to all the panel members. While Anju spoke about that you cannot be dismissed if, because you have been performing a particular role, what happens of those subtle retaliation? Okay, like it won't be like as severe as dismissal, but it could be some subtle retaliation that an IC member could face. Maybe not giving them a promotion because while the background reason is this, but portraying some other reason that they are not ready for it, right? Because they handled a case against a senior member. So how is there anything in black and white, or if there is nothing in black and white, is there anything an IC member can do to protect themselves, or employers can do to protect the IC members? So any input on that, anything that you can throw light on? So this is for Namrata, Tripti, Anju, whoever wants to take it.
Smita, I have one thought here. I have always felt things like going and voting for election or doing a public duty. Your employer is duty bound to allow you that. So when you are sitting on a statutory chair, which is over and above your regular working hours and your regular employment, and you're doing this for the organization, it is an organizational compliance issue, your employer has to allow you that. And whatever you do during that time, it cannot come back on this. And this is something that can be bridged in the IC guidelines that we had discussed, because there should be, I understand what you're saying, that it can be very indirect. In fact, I think more than dismissal, things like promotion or not getting a good project or personal interactive differences coming with the IC members is very common. But having said that, the same risk would also extend to any disciplinary committee which sits in an organization. If you look at it, it's just that one is statutory, one is not. But otherwise, the level of work, the duty performed and function is same. And this has to be called out by the employer. Anju, Namrata, we all have been saying that a lot falls on the employer, because the responsibility of compliance of law is with the employer. And compliance of law requires you to have a committee which can do A, B, C, D, E. Now, the section 16 that Anju was referring to is also the minimal guideline given. That is true, but that is only where an IC member is also wrong. Now, it doesn't talk about where an IC member is not wrong, but the IC member has to go through that exam any which way. Like she said, you still have to hire a counsel, you have to go through the entire due process of law similarly. So that is, I think, where the gap or the challenge is. And the employer must make it very clear that unless there is past precedent of non-performance, neglect to work, things that you would look at in a normal employment framework cannot be extended to your IC duties. When you are doing your IC duties, you are performing a public duty, a legal duty, and that should be kept separate, which is why IC is always called an independent body. It is not within the framework of your employment. So it has to be treated independently. And this is, while it's there in an implied manner, it is being done also in an implied manner, but I think calling it out, I take your point that, if it is put there in writing, it will create a certain assurance in the mind of the IC member. It also is a deterrent to people who can indulge in such behavior, that there is a policy which says that if you do this, or if you, take on any retaliatory actions or create an environment where an IC member feels threatened, the very same safeguard extends to them also. It is a deterrent when it is put down in documentation, when it is made part of your code of conduct, that any committee or any person, including even your supervisor, your disciplinary committee, your POSH committee, ethics compliance committee, whichever, they are doing a job which is different from their employment structure. It is a legal duty that they are playing. And I think that distinction must be cultivated as a culture, Smita. I mean, that is the need of the hour more than anything else. You can put it on paper, you can train, you can conduct awareness, all of that will help, but it is a part of an organizational culture, because this is human behavior we are talking. Retaliation, sexual harassment, all of these are behavioral aspects. And in time, hopefully that will, start changing.
Absolutely. It has to be.
And just to add on to Trupti's point, in the event, there is any retaliation that happens, actually the IC members can also approach the labor commissioner and go through the normal process of, the court process of being appointed back, or to dig into the reasons of why he was dismissed and to give him adequate compensation. So the law provides that sort of protection also, but that is also provided to every other employee. So that's the distinction, that what protection is provided to every employee is just the same protection provided to an IC member. So I think through this topic, we're trying to throw light that an IC member should not just be treated as just another employee, but there has to be at least a level extra, where an extra protection is sort of provided to them.
Yeah, I think that's a brilliant aspect, that because sometimes I think we forget that we also have this. We can go to labor court, and somewhere I think people are also scared to go to courts, right? So we'll have to first see what as an employer we can create, and of course, and make them aware, or constantly speak to them. As an external member, I take the responsibility to ensure that I speak to our IC members and tell them about their, the protection or safeguards that they are part of. And I also like the idea of, sharing. I mean, while y'all were speaking, I thought I had a kind of a bulb, which every time when a complainant or a respondent walk into the room, IC members make them sign a non-disclosure agreement. We talk about confidentiality. We talk about, ensuring that they are saying truth, and whatever they say is true to the best of their knowledge. In that, I think we can also tell them about IC. We can tell them that retaliation against, while we say retaliation against complainant is non-tolerable, we can also mention things like retaliation against any of the parties is not, including witnesses. I don't think we even talk about witness retaliation, right?
And I would just, Smita, I will just add a very small point that I would actually like to highlight, that is already mentioned when it comes to retaliation, and this recourse the complainants have under Section 12. If a complainant provides a written request to seek interim relief from any anticipated retaliation and victimization, then this is under the discretion of ICC only. Okay. So I specifically brought this issue of Section 12 POSH law, that how it safeguards the complainant from being victimized and being, at the receiving end of receiving retaliation from any of the employers or other people in the organization. But we IC members, when we face retaliation of the organization of which we are also a part of, where do we go? And this is one, somehow I feel that there's a loophole. It need to be properly, adequately addressed. And as already discussed earlier by Tripti and Anju, that at least, for the time being, we need to have, the organizations need to be inclusive in, enough to learn to respect IC members, learn to respect the dignity of IC members as well. And that's how they can, do that by, as already recommended by Tripti and seconded by Anju and you also, that we need to have written guidelines, code of conducts of ethical behavior, not only towards our employees, but include the IC members also in it.
I just have another thought here, Smita. I totally have to agree with what Namrata and Anju is saying, but now I'm going to spin the bottle here, for all of us to complicate matters, since we are lawyers and we can't not complicate matters. Now, all of this we have been talking from an employer perspective. Now I come to the IC mindset. Imagine all of us have been IC members, are IC members, external members or internal. When you are open to scrutiny, you have given me a job I'm not trained to do. You have made me sit on a quasi-judicial chair. And now you're telling me labor court jao, yahan jao, appeal ho sakta hai, all of that. And you're opening up my work for scrutiny, which is why I bring back the point to skill set. IC has to be equipped with proper training and skill set so that they can leverage these protections that we all have been discussing. Because half the confidence will be if I know that I have to go and my work is going to be scrutinized and opened up, I will not even approach the labor commissioner. I will be like, why to do that? Already my work is hanging there. This is an extra duty. So I think that confidence also matters so much, which at every step is as such tested. And on that, you are not even equipped to handle it.
Yeah. So, so true, Tripti. Actually, I have known of, it's very sad statement that I'm going to make, that the presiding officer of one of the IC saying that she was herself being sexually harassed by many people in the organization. She was a single woman, and people thought that she was available and all that, you know.
She
So
was the legal head, wasn't she? I think we are speaking about this.
no, she was not.
Okay, then there's another matter. Okay.
Yeah, different matter. She was a presiding officer of a particular organization, and I was shocked and aghast. I said, "You are the presiding officer of internal committee. How can you allow anybody to do such things?" She's like, "That's the culture of the organization." And as you rightly mentioned, the culture, okay, has to change. So I tried my best to tell her that stand up for yourself. I tried to speak to the employer, okay, to help her be the employer, and the try said that, you know, you step down and complain to us. So that lady, who herself is the presiding officer, was not ready to make a complaint herself. So I then had to sit down with the employer and say that, is this the right presiding officer? Okay. So we had to actually sit down and say that, till the time we need to get her out of this. So this is such a hodgepodge kind of a scenario. I mean, anybody, what do you think should have been? I mean, I'm just giving you a live case which I had to handle. What do you think should have been done? Any inputs will help. I know it's a little live right now, and what do you think should be doing in such a scenario where the presiding officer herself says that I've been sexually harassed and she's not ready to give a complaint? What is the kind of culture that we are talking about in that organization?
You know, like Trupti said, I think I completely agree that when you choose your set of panel members, it is extremely important and adequate that you train them. And the training should be imparted some professionals, not just, you know, the employer doing it for the heck of it. Because I've heard so many people actually telling me that, yeah, we had this training session, but yeah, chalo, we've just, you know, signed it and said, yeah, we've done the training and things like that. I think people should start taking this more seriously, and there should be consequences if this is not taken seriously, if training is not imparted in the right way. Because if the presiding officer fails herself, then there's no point of the act. The entire, you know, the whole process of Vishakha judgment in 97 and then the act much later in 2013, it's all for a waste, you know. And it's not just waste of the judiciary, the legislature, there's everyone's hard work involved in it. So I feel employers should sort of take a stand, and the respective state governments should implement a, you know, penalty that, okay, if you're not going to comply with these things, then there is going to be some sort of fine imposed on you, or some you know, a minimal penalization imposed on you. Something should be there so that they take the entire process seriously, and the members who are appointed should be adequately trained. And if they fail, then justice fails. So there's no point.
Trained and empowered stand up for their own cause. I mean,
yes.
I was so disheartened. I took some time to get my thought process together when this was happening.
I have advised written exams for IC. I say, please exam karte hain, because that's the only way you will have a checklist and you know the process packed down,
Right.
you know, to create seriousness. Because you're sitting on such a chair. And not just that, you're also sitting on a chair where your decisions impact other people's careers and personal lives.
Yeah. Absolutely.
Yeah, written examination is a very good idea. That is also something that I'm going to pick up from here. Namrata, anything from your side before we put, because I have another question which is very, very relevant for a lot of people here. Anything that you want to add in this whole scope of retaliation?
I completely agree with what Anju said, and what brilliant suggestion Tripti has already made. And actually, these are that is why it's brainstorming is required. But again, I will go with one thing, that what if the other IC members or the employers were open enough, were inclusive enough to have encouraged that presiding officer that you are setting up a wrong example by not standing up for your own self, and how can you then protect the rights of the complainants and the other employees who will come to you? So you must set an example, and so the organization must inculcate a kind of culture, inclusive culture. They must unlearn something, and they must learn to have an inclusive setup in which they train the IC members as well, that yes, it is very important if anybody is, poking their finger at you or troubling you or making you feel offended, then stand up and take action yourself, because preaching is very easy, but practicing, it takes a whole lot of courage, and it's a different ball game altogether.
Yeah, you hit nail on the head that it's very easy to stand and tell people do this, do that, but when it comes to you, how do you action on it is that's the true test. I think Trupti, yehi test lena chahiye. Maybe we should put them in a situation. So it should be like a live thing. We should put them in a situation, see how they behave, right? I think
Yeah, like like lawyers have moot courts before they pass out. I think there should be like some moot session should be there for the IC members.
Like some mock proceedings where you are the complainant or you're the respondent,
right?
And how you would be handling it,
right?
And again, I feel that that presiding officer, she should have been bold enough, and she should have the audacity to resign as presiding officer instead of just holding on to the post and not standing up for what was wrong, what was injustice that she had met.
More so because she's on the chair. I mean, she herself should be somebody who has it as a propaganda. I mean, she's one person who could be speaking about that sitting on that chair.
Yeah.
Agree with you, Namrata. That's all.
Absolutely. So having that strength. So just to give you all a little bit of input, at KELP HR, we do this. We call actors who behave like a victim. We call actors who behave like a respondent, and we have a scenario where ICs are asked to ask questions to the complainant, and these actors do some amazing job and put them to so much of stress. It's so nice to watch them. Sometimes you get goosebumps because they're real actors, and they understand the subject, they understand what is Posh all about. So we put them in those scenarios as you said, the entire mock procedures we conduct. We also have hostile witnesses. So we put them through that situation where, a witness who's not sure, doesn't want to do things. So how do you ensure that, you get the right things out of that person? So we make them do that. So a little bit of things that you just mentioned. So, Trupti, I come back to you for one very important question, which always comes to me from various people, that if I move I'm a part of an IC, okay, and there is a complaint which we resolved, okay, but I am quitting that organization, and now an appeal is come against that particular case. I am moving out of the organization, okay. Now, this organization may not protect me, right? Because there will be legal court proceedings. So what happens to my situation? How do I deal with this whole court case, and what will happen to my status?
That's a very, very good question, Smita, and especially so relevant because, in the corporate culture, we all keep changing jobs, or we move in and out of organizations or even locations. Now with remote working, most of us have relocated to back homes or closer homes and things like that. Now there is a bit of an overlap here. If you look at it very strictly from a legal perspective, IC is one body. But when you look at the implementation of it, each member has a different story and a journey. Now, everywhere the law addresses it, it addresses IC as one unified holistic body. But when a person quits, it is only one member moving out. The IC is still standing. So there is a bit of a, which is a variable component and which is a fixed component kind of a math going on here. So when it comes to this, I think that your exit letters, typically most of our employment exit letters have a clause that any action you have performed during your tenure in the company, it may come back, because limitation law generally is 3 years. Tax limitation is 7 to 8 years, about annually. So about 8 years. So there is a scope that matters can come back to you even after 5 years after you have quit an organization. I think the same rationale needs to be applied at IC level. And you have to understand that you would have made notes, you would have had records of what you have done when you were an IC member, and you're bound by confidentiality. Apart from your appointment letter, a proper IC termination letter must be issued when the person is moving out who is an IC member, along with your employment termination or relieving letter. Your IC resignation letter also must be on record. And there should be things either in the guidelines or in that letter, similar to what we said should be in our appointment letters, even in exit letters, that if there is such thing, you will be called back. You may be called as an evidence or some evidentiary value or a witness, just to kind of corroborate what you have been through, because the matter may go to appeal or the matter may get more serious. It could happen, or the same complainant or respondent may reopen with another incident and there is past precedent. It could impact on a background. And I think it's also prudent when you join a new organization to mention these. All of us who are, in senior positions, we do mention that we were sitting on senior chairs and there are matters which we can't discuss and we may be called back if there is some issue, especially special projects and things like that. I think that's how this should be considered. When there is a special project, you are given leeway even from your current employer to go back and attend, especially when the matter is an appeal. It is a court proceeding, it's a court summons. If you don't go, you will be in contempt of court any which way. So it is again your legal duty of the chair you were sitting in to just go back. You will not be fully involved. You just have to go and give your bit of it, because IC as a whole still exists. You're just one member. So I think that differentiation and that cooperation from both employers is a fair ask. I feel it is a very fair ask, and it should be something that's in the policy, and it is at par with your normal employment duties also. Even if some project you have worked on, an issue comes, even after you leave an organization, people call you. They may ask you, what happened? Do you have some past email or something like that? So same leeway should be given. Another good practice or simplified procedure is having a common email ID for IC. Like you could have whatever, posh at so-and-so.com or whatever, so that all the records and everything are present there. So that even if someone resigns or quits, unless it's a personal viewpoint or a dissenting opinion, from a records perspective, it is all there. And the organization doesn't have to really bother people and drag somebody into a legal proceedings after they have finished their tenure. So that way, there is a very good record keeping, there is clean hygiene, and there is a proper sign off and rationale. So that is another tip that I could think of, which can simplify procedures in an organization internally, because now you're open to legal scrutiny, right? So there has to be an audit trail there. I think that is how I would go about it, keeping organization's reputation and my IC members' interest and the complainant's, or respondent's cause of justice. To balance all three, I think the organization has to have proper safeguards and mechanisms which are doable in real time.
All right. I think that's a fair suggestion, and having these open conversations, especially because I see people are all going to be in senior positions, and they should be able to put that down in black and white to their prospective employers. Right now, I have one question for Anju. Actually, Anju, is it very easy to go to? Can any complainant or respondent appeal? Is it very easy to, as a petitioner, go to a high court against your IC?
Throughout from the day the POSH Act has been implemented, I think the clear and sort of consistent position of our courts have been that though we have appellate powers, we are not going to interfere in the judgment or findings of any departmental authorities. More so because IC is a body which is quasi-judicial. It is independent and it has enough powers to pass orders and findings. Like I said previously, you cannot call IC as a mere fact-finding body or a mere preliminary investigating body. Whatever report or investigation is conducted by the IC is extremely conclusive. And to go on an appeal, you need an extremely strong ground. If there's another judgment actually by the Rajasthan High Court, which is one of the landmark judgments and one of its kind. This was passed in, I think, Vidya Akve. The petitioner's name was Vidya Akve. In this case, if I may just explain the case briefly, in this particular case, an employee, filed a sexual harassment complaint against her colleague, and an IC was constituted, and the respondent was held guilty of the charges that he was accused of. So, there were certain, based on the findings, certain disciplinary actions were taken against the respondent. One being he was transferred, his pay scale was reduced, and he was also demoted, if I'm not wrong. What he did is he challenged this order before the appellate authority. So the court, upon going through the findings, the court held that there is no disproportionate order passed by the IC. So you have no locus standi to come and approach me unless there is, an apparent error on the face of it, like if it's completely against natural justice, or if the IC members have refused to call in witnesses, have refused to take on your materials on record, or if there is the principle of proportionality is not, upheld, only then can you go on an appeal. And this is another wonderful protection because our courts do not entertain any appeals which, unless it lacks merits. So you can't just randomly go on an appeal. That way, any person who is deprived of, the IC passes an order against you, that person will be like, okay, anyway, this is an IC. They don't know the importance or the value of the position. They'll be like, chalo, I'll just go on an appeal. So it doesn't make sense. Then there'll be like thousands of cases pending before the court. So I think this is an extremely important stand that our courts have taken. It's a very bold stand, if I may say, because the fact being IC members are not legal professionals, though they are trained professionals, they're not legal professionals. Even then, our courts have held that no, chalo, we'll give them, independence, we'll give them the power so that they can pass orders, and those orders or findings will be final. They are crystallized. You can't approach the appellate tribunal unless there is an extreme distortion in the order, or if it's extremely apparent on the face of it.
Yeah, I think that's a good one, because many a time we get threatened saying, I'll see you in the court.
Exactly. But that doesn't happen, because, yeah.
Sorry.
That doesn't happen that way.
In fact, another safeguard there from an organizational mandate is why we need to are required to file annual returns. You see, because that is something which is a disclosure of information. So as she said, it's not just easy to, go to court, because it is a case. Somebody has to win, somebody has to lose. That is the nature of the subject matter itself.
Absolutely, yes. So it is important that we have an appellate, but then, throughout the cases that we handle, we always tell our IC members, think from a perspective what will happen if it goes to the higher court.
Smita, in fact, I have advised an IC checklist, apart from guidelines, because when you have a set checklist, it is a very process-oriented mechanism for people who, as Anju and has mentioned, that now these are people who are not lawyers.
Correct.
And their work is going to get opened up. So unless there is merit, it is very difficult to reinvent the wheel. I mean, courts cannot keep reinventing the wheels when already the IC has determined the matter.
So that's exactly what we do, because we also work with non-lawyers, right? And as you rightly said, they are not trained, they are trying to learn, they've never handled a case. So a checklist really helps. So we also try and put step 1, step 2, step 3 in that process, so we don't miss out on the process. Absolutely. I think these are some brilliant suggestions coming in. One thing, Tripti, as I heard about a PIL which Advocate Abha Singh has filed on similar subject, which is, I guess, very hot and going around on the subject which we are discussing right now. So do you want to touch upon that?
Thank you, Smita. And this is something that makes me very happy to speak about as a POSH practitioner, because what Abha has done or has tried to address is such a, not just a bold step, but such a needed step, where the law has not been able to draw that parallel. Maybe when the lawmakers were drafting this, they didn't probably see the the impact it could have had, because we are trying to, it's a criminal offense being done by a civil body. IC is a civil court power, but it is a criminal offense. On top of it, it's an organizational atmosphere, not a general out in the society atmosphere. And IC is not police, IC is not judge. So all of these gaps that could have come, Abha has tried to bridge it so beautifully in this PIL. Anju, just help me out with the name. I think it's Janki, right? With her?
Janki Chaudhary.
Janki Chaudhary, yes. So Abha and Janki Chaudhary have filed this PIL before Bombay High Court to bridge certain gaps, which over a period of time, we have seen how the POSH law has evolved. We are in 2022 today. By next year, POSH law meets a decade. And this is a decade-long collection that they have brought to the forum, where we are saying IC members are treated as judges. They're given powers of the judges, but they are not given the protections of a judge. as Anju already mentioned, that immunities that are given to judicial officers, to judges, is something that is lacking. It is a criminal, for a criminal matter, civil powers, there is a bit of a confusion there. And there's a distinction between the way the private sector and the public sectors are handling it, because this is a public servant duty that you're doing. It is a legal duty that you're performing as an IC members. And the very cornerstone of the enactment, which is that protection to a vulnerable section or women and a safer workplace, that same protection must be extended to IC members. Even IC members have a right to a safe workplace to perform their functions well as IC members. So without getting into too many nitty-gritties, the idea of this PIL, from the way I understood it as, is that the powers which are given to judges, the power which is given to public sector, to local committee members, should also be extended to IC members, which will actually mitigate a lot of retaliation and a lot of backlash that can come to them in their everyday job, and to enable them to perform the IC role very well. And Anju and Namrata, please fill in the blanks that I have missed out here, or if you have something to add to this beautiful fight that ABHA has initiated.
I remember discussing so passionately with the three of you. So
yeah, no, I think anyone even who's remotely involved, with the POSH Act, or who's a practicing lawyer, is eagerly waiting for this judgment to come out, because I think this will sort of change the foundation of the POSH Act, because the most important factor which had to be considered has sadly been missed out. And ABHA and Janki Chaudhary India petition, it's a beautifully drafted petition where each and every problems that we have been mentioning has been beautifully sort of put forth before the court. So I think this judgment is going to sort of change the foundation of this act, if there's a positive outcome of the judgment, which everyone is hopeful.
So the Live Law has already uploaded this pleading. So any of you who's interested to, read this beautifully well-drafted and well-articulated petition must go and read this ABHA Singh and Janki Chaudhary's petition. And kudos to them that at least they are addressing it now, that we are just about to finish 10 years, complete 10 years of POSH's existence. And I, as all of you are also eagerly awaiting, even I am awaiting the verdict in which we as IC members would be regarded as public servants. Our interests and safeguards are going to be well taken care of, and let's be hopeful that verdict is in our favor. So we are just eagerly awaiting, and more teeth to them. And it's a bold decision that they've already taken. Let's see how it goes.
And it's also sad that it took so many years for these two brilliant people to come up with this. Like I'm surprised that no one thought about this much earlier. It took almost 10 years for people to realize that okay, the IC members are not protected. So that's also a really sad state of affairs. For 10 years.
Many times, Anju, many times I used to feel just disheartened and disappointed. That okay, now I have to abide by the principles of natural justice, principles of proportionality, and abide by what the laws say. And that is how I was restricted, and that's how I was feeling disappointed. But at least people are thinking and in the lines out of the box that they should actually approach the court and fight for what actually we deserve. We as IC members, we deserve it.
But I think also, Anju and Namrata, I'll differ with you here a bit. While intent of all of us is same that it's great, but I'm actually glad that it took this time. You know why? Because they have enough fodder to go back today and tell the court. This 10 years has been such a learning. At one level, I'm sure Smita, you will agree to this. So many of us are thinking कि कल तो POSH Act आया है. मतलब लगता नहीं है कि it's been 10 years that we all have been, we are still learning, we are still getting tricky cases, breaking our heads, hair splitting. But in the same breath, I feel that the law had to play out we had to see how it plays out for them to have enough research and material to go and knock the doors confidently and make a good meritorious petition, rather than doing something which we should have done it without having the research or the actual incidents backing it. So in that sense, I feel that yes, it is better late than never approach. But today there is so much more a confident fight there, because it's happening now. You can't deny that IC members require protection. Before it was a mythical concept, but now it's a reality.
Now it's proved. Yeah.
So I remember this famous discussion that I had with LCC, two LCC members of Mumbai. And I was like, there are so many loopholes in the law, it is not fixed. I don't know what will happen. I mean, I'm not very confident, this and that. So the response that I got from the LCC members is that, how old is our constitution? Right? It's 70 years old. There is loopholes there. There are gaps there. We are still struggling to find out what it is. This is just 7 years old.
The Indian Penal Code is 1861. It took a Nirbhaya to change that in 2012. Criminal procedure codes were amended.
So they are like, chill. So they take it with a pinch of salt. So I said, okay, fine. I think we have had an amazing discussion, and I didn't realize that we are like 15 minutes above time, because I was so engrossed in this conversation. Any final comments from each one of you till that time? I'll just see if there are any questions. There are questions, I know for sure. Okay, I'll just peep into the question, and if we can respond to, somebody is asking us to do some research. Bhargav is saying, do some research, please. Bhargav, on it. Is there any online facility? Swapnil is asking, is there any online facility for the protection of IC? I don't think so. Anybody knows this?
No, none that's come into picture yet. Hopefully,
has official
soon.
power. Yeah, you may have groups and forums which can support you, and you can approach them. But officially or mandated as a redressal mechanism for IC, I don't think so.
So, somebody asked which petition. So it is by Abha Singh and Janki Chaudhary. Malini, what I will do is, when we send an email to all of you, we will, the Live Laws Act link also.
High Court of Mumbai. Yeah.
We'll send you the link so you can read through that. So I think that is what Malini.
It sounds good, Smita.
Yeah.
Thank you so much. And Smita, I just have one question.
Yes.
This is a technical question.
You have 3 lawyers here.
External committee member.
Okay.
Yeah.
Sorry,
so it could be a little off tangent.
We lost you for a bit. So
it could be.
Go ahead.
Am I audible now?
Yes.
Yeah, it could be a little off the tangent. It's as an external committee member, when they're giving recommendations, is the external committee member expected to sign the recommendation sheet?
Yes.
For the orders passed, or is it just the presiding officer, or all
the
external member as well?
Everybody. It's a joint. Okay. It's a committee. It's a committee report. It's a non-legal response. So, Tripti, Namrata, Anju, please edit if I'm saying anything wrong. What I understand from my experience, that it's a committee report, so all committee members have to sign it. Tripti, Namrata, Anju for technical.
Yes, all the members present during that discourse and meeting, they need to sign it. Not one, but all.
All. Yes.
Great. Thank you so much.
Thank you, Malini. Bhargav is asking another question, perhaps some good research or PIL on the case of ex-CJI shall be the answer to the most of issues being discussed by the panel members. May also make some amendments someday if shall be taken up. Bhargav, that's a great thought, and I don't know, I don't have a response to this honestly right now. Anybody? It's a suggestion that can we do some research or PIL on the ex-CJI case.
I think you have 3 lawyers here who will not speak about the former Chief Justice of the country in an open forum. But yes, it's a good thought. It's a good idea.
Yeah, Bhargav, it's a good idea. Maybe, yes, we could take it up maybe in future, but there's so much of work right now on our platters, and we are short of hands and legs, honestly. Please raise your hand. KELP HR is ready to support you in any way provide you resources, whatever is required. ILA and KELP HR can definitely provide you. But right now, there are so many larger issues. I know this is also a very big issue, but lack of resources is one thing that for sure. So Bhargav, if you're interested, please. Thank you. I think Sijimol has already pasted the PIL thing. Thank you, Swapnil. I think nowadays office hours being online are not defined. Does that make POSH and cyber law overlapping?
Yes. In some cases, yes. There are cases where even forensic investigation has been called because there is traceability. But the good thing is because it's online, there is electronic traceability to actions. So it provides for a more definitive evidence.
Yeah. Yeah. So honestly, prior to that also, cyber laws were always used. I remember using cyber law for a POSH case in 2004 prior to Vishaka, the 2013 Act came. So we used cyber cell, we used cyber laws to pin the person. So yes, we have used it and very effectively used it. Are online inquiries lawful? Supreme Court is doing that? Is it Supreme Court doing online inquiry, online proceedings?
Surviving in the COVID era, I must say, pandemic, yes.
Yes,
when the courts are doing it,
awful.
and when the courts are doing it, and if any employers or the ICC, everybody gives consent to it, I don't think so there is anything wrong if in conducting it online.
I agree with Namrata. Unless a complainant or respondent really asks for an in-person hearing, very, given the sensitivity of the issues involved, per se, online is as good as offline with the consent of everybody. But if they do ask, then it is for IC to determine.
What happens if the complainant do not appear for 3 consecutive inquiries?
Ex parte order?
No, a complainant.
Complainant, then you, okay.
Then we have to drop it. Complainant, then we cannot, if you have all the, okay, this is an HR response and I'll ask legal to pitch in, but what we do is we send it to inquiries. Sorry, there was some disturbance. So we send 3 notices. We wait for 15 days gap in between and still the person does not appear. Then we have an option to drop it, but I generally don't prefer dropping it. We go back as an IC, sit down and figure out if we have enough material in the first complaint letter that she must have given. Okay, and if there is enough, then we go ahead with the proceeding. But if we get stuck and we cannot proceed, that's the only point when we drop it. So this is from my perspective. Anything from Tripti, Namrata, Anju?
I think it's same, Smita, but just that the record will be made correctly.
Yeah.
It all be documented correctly and then dropped so that tomorrow an IC is not called into questioning as to why they were not, it was not proceeded with the proof of how you have sent it, whether it's read receipt with email or your SPAD, RPAD, whatever be stored and kept. Because these are all matters where things can open up, and now IC has to start having evidence for the actions that they also do.
And let's hope so that whatever decision IC does, it does it within 90 days. And if the complainant doesn't come to them in the 90 days, as suggested by Tripti, if they have documented everything, they document each and everything that they have already sent notice number 1 for 15 days, waited for her, then 2 or 3, and the complainant doesn't come with a genuine, reply that why the delay or why there was, why she was absent, why she couldn't come. Sometimes they are subjected to mental agony and trauma. We
People
need
at
to
home
step into
stop
the shoes
you.
of a complainant. So if there is no genuine reason, so then we must go ahead and submit a report, and only recourse again that is available to that complainant is then she can now go to the LCC.
All right. Thank you so much. I think Bhargav has some exciting case study about some high profile case. Bhargav, you want to unmute and share with us because I think you're taking time to type it out. He is okay. Surekha, thank you so much. Yes, we'll reach out to you, she says. And he also, Bhargav is also saying that he'll be happy to participate in any PIL if you want to do against CJI. He's ready. He's raising his hand to do that. So no, you don't have to apologize. I was just saying if you can unmute yourself and tell us about this case. Looks very exciting, but it's come in bits and pieces. A lawyer migrated to UK, has been so interested and being engaged. All online hearings, court hearings are online, and therefore inquiries can be taken up. Yes, Bhargav, if somebody wants to, okay, that person is living in UK. So the lawyer is living in UK. And as an external member, he wants to participate. Are you saying that? If there is a high profile case, the lawyer migrated to UK will be eager to appear online. Bhargav, it's a very individual question.
Smita, he also mentions as if there are no lawyers in India.
There are no lawyers now in India. You know who is the lawyer? No, I don't know. Am I missing the point?
Yeah, I think there's a break in the messages, so it's not.
Yeah. Bansuri, you have raised your hand. You want to say Banusri. Sorry, I'm not.
Thanks for pronouncing my name correctly. It is Banusri, yes. And definitely I have two things which I can put before the panel. They are very good, actually. I have been getting a lot of information from them, from the personal experience as well as professional. The first thing what I have in my mind is how to treat a hostile witness. How do we proceed further as an IC member? Number two is actually also on how actually IC should treat the immunity aspect of it. When I am relieved, I am also in 2-3 organizations. When I go out, as they rightly say, they don't give a letter. I write to them stating that whatever I have done here is actually disclosed for all purposes, for all intents. So hereafter, I will not be summoned as witness, etc. So is this the way we have to do if there is an absence of policy?
To start off with your first question, there is no particular way you can treat a hostile witness. A hostile witness is hostile for a particular reason. So there's nothing under law which says, there are these set of rules or, these set of procedures that you can apply on a hostile witness. So
I want to know what IC will do, what IC should do.
IC also is not conferred with any powers to, if it's a hostile witness, you can't really take in anything what the witness says. The witness has gone against what he or she has stated earlier. So whatever the witness has said will be recorded, but it is treated as sort of, I wouldn't say nil. It is what to say, she or he has gone back on her words. That's about it. For example, in a court of law as well, when there is a hostile witness, the witness would have initially said that, okay, I saw this happening, or yes, I was a witness to this particular act. But when she's called as a witness, they may change their stand saying, okay, I'm not aware of this. I was sort of pressurized to say this. I was in a state of fear. That's why I said it. So it's this, and the court cannot do anything about it. The court will just record what was stated earlier and what has been stated subsequently. It's the same that the IC panel members do. Everything that has been stated prior and subsequent will be recorded, and based on that, an order will be passed.
Adding to what Anju said, Anju, that's actually a very very good way that you put it, comparing it with the court proceedings, is what IC can do is give an option of anonymity. That one thing you have under Posh law, that if because I understand here there is a direct hit on employment. Unlike a court where the judge doesn't know you, or it's a personal matter, property matter, divorce matter, that's a different set of considerations. Here it is a direct hit. These are people you work with 12, 16 hours a day, every day. These are people who are your colleagues, which is why there is an option of anonymity that can be tried. Not that can prevent, hostile witnesses or can completely clean the problem, but at least there is one little bit of an olive branch that you can use there.
Yes, we actually use this anonymity quite a bit. We redact the names of the witnesses. Now, hostile, as Anju rightly said, hostile witness is a hostile witness, and you cannot do anything about it. You cannot force a witness to stand by what they said earlier. It's their right. But if they lie, if you find out that they have lied, okay, and you have enough and more proof showing that they have lied, so you can use IC powers, of course, with the help of HR, and reprimand them. So they cannot lie because you are a civil court, right? So you have that right. Okay. So Banushri, is that enough input for you?
Definitely. I'm waiting for the next question.
Sorry, can you just repeat the question, the second one?
The exit one, yeah, the exit one. I'll pick that up, and Anju and Namrata and Smita, you guys can chime in. On the exit thing, I don't think you can, as you rightly said, if there's no policy, you record what you have done and sent it. But typically your NDAs are perpetual in nature. And I don't think you can refuse that, I cannot be called as a witness, because this is now not in the hands of your organization. If the matter is on appeal, or somebody has gone and approached alternate legal remedy, an alternate forum, it is your duty to go and appear and give the knowledge that you have, which could also be this, that all my records are in the previous organization. Everything I have to say is there. But I think refusal will amount to contempt. And it will also reflect, if you're sitting in your current IC, even your current organization may feel that, if tomorrow something happens as IC members, you won't stand by them. If we are expecting the organizations to support us, I think it's only fair that we also extend that support. And IC duty does not stop with your tenure of employment. These are things you take with you in your heart, right? Even if you leave the organization, you're bound by confidentiality. You have internal understanding and knowledge of certain matters, of certain people, their personal equations, which have come out during a case. So I don't think you can refuse, but what you can do is record it. You can give them a certain, assurance that I'm there. But having said that, I have fulfilled everything. All my files are stored like this. It has been handed over. The laptop has been handed over, so that the hygiene of it is very clear and maintained. And if it's any responsibility, also because a lot of this is sensitive data, you will get hit by data privacy also once the law comes in, which is somewhere on the horizon currently. So there are multiple laws at play. So I don't think one as an external member or as an IC member, we can just say we will not come back, because you were there in that matter. Your signature is there on that paper. But yes, if there is no policy, you yourself can record this on email and send it to an employer. I think that is also a good practice.
Thank you. Thank you.
Yeah, I think we have responded to maximum all the questions, and it is almost half an hour beyond our time. Do one thing. What I can do is display here few of the places that you can follow or write questions. Of course, you can write questions to info@kelphr.com or posh@kelphr.com. I'll just type it out in the because then we will be celebrating our Saturday, Sunday throughout, while we are happy to do that. But then I think that we should respect all our folks who have been spending so much time. Thank you very much, all of you, Tripti, Namrata, Anju, and all of you who participated in the discussion, the participants. I think it was a great discussion. I thoroughly enjoyed. I learned quite a bit, and I'm very grateful, because every time I listen to a lawyer, I get an idea, and I'm taking at least 2 or 3 ideas today from this discussion. I hope all of you had a great time. Any closing comments from Tripti, Namrata, Anju?
I would say one thing, that
Namrata, you went on mute, Namrata.
sorry, organizations, I will say one thing, that organizations must project themselves as truly committed to inclusive workplaces by encouraging not only their employees to speak up, but also IC members. And IC members must voice out their discrimination and any biases that they face, and organizations must address them. And let's try to be part of workplaces that would rather nip the behavior in the bud than have a toxic work culture. And this change, as it was discussed in our panel discussion, in this attitude is a process. It will take time, but it is bound to happen. So let's leave on a positive note.
Absolutely. I'm up for change anytime. Tripti, Anju.
Absolutely, Namrata and Smita. I mean, we are touching a subject of sexual harassment. It's not a happy subject. And there is so much more riding on it. And I think, as you said, it has to be an organization's risk appetite, that it's not just a business intent, but things like this happen. These are real people, real problems. These are all of our problems. we all are battling it at different ends. We could be employers, we could be IC, we could be external members, we could be lawyers, we could be HR people, or we could be women and men who generally are involved or passionate about it. It could happen to our friends, our spouses. So everyone can feel about this subject. There is somebody who knows somebody who has been through something like this at the very least. And I shouldn't say this very proudly, but India mein to every woman can say me too at some level. Kam se kam aapke taraf CT to baji hi hogi, if not anything more serious, and heaven forbid that. But on that note, I think it's a great platform, and that all of us are coming together, brainstorming and discussing, and trying to make a difference. And it is great. The more we get in, the more difference it can be made, because this is not one problem. It is a mindset change, and it will not happen overnight. Most people don't even realize what they do can be sexual harassment. So it is not just ignorance, it is so normal. And I think now that we are all anyway being dealt with the new normal, I think this should also be something that should be a part of it. And more power to all of us to help and strengthen the cause further. Thank you so much, Smita. Thank you, Namrata and Anju.
Thank
all
you.
the lovely audience.
Thank you
You
so
know,
much.
I just want to add that I think till there's a law formulated, the employers should sort of take up the responsibility to protect the IC members and to do the best that they can do for their protection. And also, I think what Smita is doing, educating people through these seminars, it's a wonderful stand that you've taken, and I hope to see a lot more of these educative seminars in the future.
Absolutely, Anju, you are as much as part of it. So we will be bugging you all the time. So thank you very
Definitely.
much for taking your time out. I know it's a Saturday. I know it's a busy day for all of you. And you raised your hand and said that you would be happy to be participating in this. Aile and Kelp cannot thank you enough. So thank you, Tripti, Namrata, and Anju once again from all of us here.
Thank you so much,
Thank you.
everyone.
Have a good
Thanks from our side
afternoon.
too. Thank you. Bless you all.
Thank you, Banushree. I'm so sorry, Banushree.
Happy weekend, everybody.
Happy weekend. Yes.
ये उसने बंद हो गई ना? Actually, what is this?